Welcome to Emphasis Added, a podcast by the Houston Law Review, where we highlight legal issues with prominent lawyers and discuss the study and practice of law. I'm your host, Kevin Donovan. I'm joined here today by University of Houston Law Center professors Seth Chandler and Valerie Gutmann Koch to discuss the ongoing litigation surrounding the federal COVID vaccine mandates, their constitutionality, and the arguments we've already seen and are poised to see regarding their validity. Professor Chandler has been a University of Houston law professor for over 30 years, teaches constitutional law, health law, and other subjects, and has been called twice to testify before Congress on the Affordable Care Act. And Professor Chandler, I didn't know this about you, but you're the author of over 100 interactive demonstrations and the founder of 2 blogs garnering hundreds of thousands of views. Professor Koch is the co-director of the UHLC Health Policy Institute, the Director of Law and Ethics at the University of Chicago McLean Center for Medical Ethics. And formerly, Professor Koch, you were the Special Advisor and Senior Attorney for the New York State's Bioethics Commission, where you crafted policy and guidance related to pandemic preparedness, among other things. So for our listeners, both Professor Chandler and Professor Koch have already spoken on multiple or on public forums regarding the vaccine mandate. And as you can tell, are a wealth of knowledge on the topic. So Professor Chandler and Professor Koch, so happy to have you here, and welcome to the show.
Thank you.
Thank you. Happy to be here.
Awesome. And so to start us off today, I figured, I'm here with 2 law professors. We're talking about a COVID-related topic. And so I wanted to start off with something maybe a little lighter than vaccine mandates, maybe not, I don't know, and it's about the Omicron variant, the newest variant to the COVID-19 virus. And I'm wondering, do you all think the Omicron variant will affect whether law students return back to school next semester or whether attorneys will return back to the office?
Well, I would say I think it's too early to say. I think we're still out as far as they're saying at least a week or 2 more before we have a better idea of the efficacy of current vaccines against the new variant, its transmissibility, how severe the COVID cases are with regard to the Omicron variant. So I think at this point, just generally, it's too early to really predict what's going to happen, but we shall see.
Right, and I think that policy by universities has been remarkably fact resistant. And so, unless there are drastic changes that are created by the Omicron variant, I think most universities will keep their current policies in place. You might see some behavior changes at the margin if this thing proves either serious or as transmissible as people are fearing. Then you might see more students who have the ability to elect to attend remotely do so. But given that policy seems to be driven an awful lot by politics rather than medical reality, I don't foresee a lot of policy changes.
That's perhaps something we'll get into a little bit more today. I don't know.
Perhaps the common theme.
Yes, but okay. Well, very interesting. I was just curious. It's my last semester in law school, so I wanted to hear if I was gonna get to go back to the old building, soon to be a new building at the University of Houston Law Center. But yeah, so thank you for your insight on that. We got a lot more insights to come, and so I wanted to transition to today's topic, which is going to be on the federal vaccine mandates, the litigation surrounding it. Particularly, we'll talk about or focus our discussion on the Fifth Circuit's opinion and the OSHA vaccine mandates litigation. And so to get our audience up to speed, I'd just like to, kind of quickly go over that, and then we'll get into discussing all of that a little bit more in depth. So to get you all up to speed, on November 5th, the Occupational Safety and Health Administration, OSHA, issued an emergency temporary standard to protect working people from occupational exposure to infectious disease, including COVID-19. And that requires, that mandate or order required employers of over 100 or more people to ensure their employees receive COVID-19 vaccination or take weekly COVID-19 tests and wear a mask. That mandate was stayed by the Fifth Circuit on November 6th, and they reaffirmed that stay on November 12th. That's the opinion we'll be alluding to a little bit, or at least I'll be alluding to a little bit in the show. And right now, the Sixth Circuit is poised to hear this suit later this month. And just a few days after we record this, the parties will have their final date of filing of December 10th. So we'll get to hear whether or not they determine to lift the stay. And then very likely, I'd imagine, we'll hear something from the Supreme Court following that. Also, just to speak to the timeliness of the topic, just yesterday, a district court in Georgia enjoined the federal government from enforcing a different mandate, its vaccine mandate for federal contractors and subcontractors throughout the entire United States. And the day prior to that, the 11th Circuit, in a case Florida v. Department of Human Health Services, denied Florida's motion to enjoin the federal government from enforcing its requirements for staff in most facilities receiving Medicare and Medicaid funding. So we've seen a little bit of difference there, but that was also kind of other circuits and courts have decided differently on that exact topic. But to stick to just one thing, because we are pressed a little bit for time, like to talk about Fifth Circuit's stay regarding OSHA's vaccine mandate. So the court itself kind of breaks down their discussion a little bit into some of the statutory challenges to OSHA's mandate, and then some of the constitutional challenges as well. And so I'd like to kind of start off looking at those statutory challenges, but I'd imagine before we get into that, we probably have to look a little bit into what OSHA is. So Professor Koch, curious maybe to start with you first, what is OSHA and what is its purpose?
Sure. So OSHA is a large federal agency under the U.S. Department of Labor, and its mission is really to assure the safe and healthy working conditions of U.S. workers. And so generally, these sorts of health requirements and measures fit squarely within the mission and responsibilities of the agency.
Got it. And so I guess the other thing to kind of just prepare the discussion here, because it's referenced a lot within the Fifth Circuit's opinion and probably will be in our discussion, what is an emergency temporary standard or an ETS?
An ETS is a standard or rule that an agency will implement in exactly that, in cases of emergency. And it enables the OSHA to pass these rules, to implement these rules without typical notice and comment rulemaking. But it's very limited, and it's only to be used in very particular circumstances. So generally, an ETS is only going to be implemented and generally upheld where employees are exposed to what is known as grave danger from the hazard, and where the ETS is considered to be necessary to address that grave danger.
Got it. And so thank you for that. I figured it's some good background as we kind of now move into maybe exploring some of the Fifth Circuit's reasoning or arguments for why the mandate, at least as they found, falls outside of OSHA's power as an ETS. So I'll open up to Professor Chandler or Professor Koch. What were some of those reasons that the Fifth Circuit had for why the mandate falls outside of OSHA's power as an ETS? And we can call it mandate or rule interchangeably. I think the court refers to it as a mandate.
Yeah, and if I may, I would love to clarify just at the outset, calling it a vaccine mandate is a bit of a misnomer. Really, it's a test or vaccine requirement. And I think it's really important that that be clarified kind of up front, that OSHA's employee mandate is really a requirement that employees either be tested on a regular basis and wear masks or be vaccinated. So it's really much more of a choice than I think calling it a vaccine mandate implies. And I think that kind of clarification is necessary as we move forward.
Okay. Well, so I will. Hopefully, my notes don't have mandate written all over them, but I will try to use requirement.
For the public that we all
No,
engage
right.
with that.
Absolutely, yeah, and that does make sense. Yeah, there are other alternatives to just getting vaccinated. But what do I mean? I suppose Professor Chandler, do you have any? What were some of those arguments? And perhaps did you find those arguments persuasive or not?
I found some more persuasive than others, and I found a lot of them overstated and imbalanced. One of the arguments the Fifth Circuit makes is that there's not an emergency here. That if there were an emergency, we're now in the pandemic for whatever it's been, 18 months, and how come you're just now getting around to issuing this? Moreover, there was a gap of about 2 months between the time, I believe, that the Biden administration announced it was going to study all of this and when it actually implemented the mandate. Now, you might think they would get credit for actually having thought carefully about how to craft the mandate and taken a variety of factors into consideration. But in the view of the Fifth Circuit, that vitiated their argument that this was some sort of true emergency. Um, the second thing that they did was really to engage in an inquiry that I think Justice Peckham from the Lochner decision would have been proud of, which was to really look into whether they thought the vaccine mandate would be particularly helpful in alleviating problems of transmission between either employee and an employee in a hospital or medical setting, or employee and patient in a hospital setting. And they noted things like perhaps natural immunity, which means having gotten sick and risked death, might work better, or that the studies on which OSHA was mostly relying came from long-term care facilities which they had not proven were identical to hospital facilities. So those were some of the reasons that the Fifth Circuit relied on in saying that there was no statutory justification for issuing the ruling, and then the statutory issues kind of get blurred in, as probably they should, with some of the constitutional issues about separation of powers.
Yeah, and to Professor Chandler's points about sort of the Fifth Circuit's opinion that this was an overbroad rule as well, I think the phrase that they used was that it was staggeringly overbroad. I think that there's certain things that that the Fifth Circuit omitted when they were thinking about this. First of all, that the opinion didn't even mention the fact that OSHA predicted that at a conservative estimate that the rule would save 6,500 lives in the first 6 months, would prevent over 250,000 hospitalizations. So to speak to sort of the emergent nature and the need for this rule, the Fifth Circuit, in some ways, sort of substituted its own medical judgment for those of the experts in many ways, which I think is one of the concerns that's being raised on appeal. The other thing that I think that the Fifth Circuit focuses on as well, in this sort of calling it staggeringly overbroad on the OSHA mandate, is that it says that it's sort of using a sledgehammer approach to to apply the same rule to all employees, regardless of whether they are working by themselves in the middle of the night, as say a security guard, versus being on the line in a more busy setting. But that said, the OSHA regulations actually did address that as well. And that's actually one of the reasons for this, I think, 2-month delay, is that the folks that were drafting these regulations really were trying to craft the narrowest possible rule for the circumstances. So, for example, the OSHA regulations exempt employees from this test or vaccine mandate who are remote workers or who work entirely outdoors, specifically for that reason.
Where I think the circuit stood on a little better grounds was in talking about what they describe as the major questions doctrine, which is this notion that Congress does not give agencies authority in rulemaking, whether it be emergency rulemaking or conventional rulemaking, to decide huge issues of social policy. And one can say that what OSHA did here, if you look at vaccine not mandates, vaccine alternatives or testing alternatives, you could say, to the best of my knowledge, that that's an unprecedented activity by OSHA, which often concerns itself with, things like the strength of ladders or other matters more traditionally related to worker safety. And so the thought of the Fifth Circuit was that this was really a decision that should be left to Congress. And maybe Congress would care to place a similar burden on medical facilities and Medicare recipients, but that one shouldn't infer that power in an agency when it had never been exercised before. And of course, the whole battle that we are having here is because Congress has refused to issue any sort of vaccine mandate. And in fact, as of recently, it's gone in the opposite direction, with the Senate having basically passed a law that would prohibit any sort of vaccine mandates. That hasn't been joined in by the House, and I don't anticipate it being joined in by the House until at least November 2020, whenever the next congressional midterm is. But we have inaction by some states, and we have inaction by Congress, and that's led to the classic setting for a separation of powers battle.
And to Professor Chandler's point about sort of the role of OSHA and the extent, sort of whether this falls within the mission of the agency, well, yes, absolutely. The safety of ladders absolutely falls squarely within the OSHA's mandate. OSHA is also, responsible for the various regulations when it comes to asbestos, and it goes beyond sort of chemical and other sort of exposure. But OSHA has also has had regulations upheld that have addressed HIV and hepatitis. So infectious disease is not so far outside of OSHA's responsibilities and authority, that I think that argument, that the Fifth Circuit's argument, still can be challenged in that way as well.
Interesting. And I find that really interesting, just the major question doctrine, because at first when I was reading the Fifth Circuit's opinion, I was like, okay, well, maybe this is, maybe it's a fair ruling in reference to an ETS, but maybe it's not a fair ruling in reference to OSHA's power and authority if it was like a typical notice and comment proceeding. But it sounds like maybe the main way that that's addressed is through the major questions doctrine, which kind of is going to speak to more to that. And so I would suppose maybe that's something that we'll see on appeal. Is that discussed more in depth in the Fifth Circuit stay?
Yeah, I think you'll have different perspectives in the Sixth Circuit, which is where this has ended up through the result of a lottery of all things, because there were so many cases that there's a statute, which I had previously never heard of, which says that when you have this number of cases regarding an administrative rule of this nature, you use a lottery to decide which circuit is going to opine on it, at least before it goes to the Supreme Court. And so the Fifth Circuit's opinion, while interesting, and it may well be followed in the fairly conservative Sixth Circuit, is not yet the final word.
Yeah, and so I'm glad to hear that is something rare, because I was like, lottery? Yeah.
It's fascinating. They put ping pong balls in a tub,
Really?
and just spin it around like Powerball. I mean, it's really amazing that the way they do this. But
hey, it's just justice. It's just, okay. But moving on, because I think Professor Chandler, starting in talking about the major questions doctrine and speaking about maybe, perhaps this is the way the courts are going to rule, is that this is outside the scope of OSHA. I'd love to kind of delve a little bit more into, well, is it even in the scope of Congress to legislate this? Or, I know the Fifth Circuit kind of talks to these sorts of things, talks to, in large part, the Commerce Clause, and just, regular federal government and state government ability to mandate vaccines. And so I guess I'd like to start just maybe with a little bit of a history lesson, and kind of start with, has the federal government ever mandated vaccinations to this degree in the first place?
To my knowledge, not to the degree. And again, I would caution against the use of that word mandate with respect to the large employers. There are mandates with respect to healthcare workers, there are mandates with respect to people in the military, but with respect to large employers, a choice has been given that says that you can either um, the employee either has to be vaccinated or they have to submit themselves to testing. And I do think there's a difference between a pure mandate and this selection of alternatives. Um, but you've basically got three constitutional issues floating around these rulings by the federal government. The first is whether Congress, if it acted explicitly, could compel people either to be vaccinated or to face a choice of vaccination versus testing. And that's mostly going to be governed by the scope of the Commerce Clause. The second issue, which is the one that we're seeing a focus on appropriately now because Congress hasn't acted, is under what circumstances can the executive branch, in the absence of action by Congress, make a similar requirement? And then the third are a constellation of issues revolving around individual liberty, which would affect not only a defense against a federal vaccine mandate, but presumably against the state vaccine mandate, and whether there are religious or philosophical bases that would shield someone from having to undergo a vaccination. And here there might well be a distinction drawn between a vaccination requirement where something is actually being stuck into your body with potential chemical effects and a more modest testing requirement, which, although in my opinion is actually more unpleasant than the vaccination itself when they stick that thing up your nose, nonetheless is seen by many as less intrusive. So you've got those three issues, the constitutional issues, that are floating about here.
Well, to tackle maybe the third one first, I mean, you talked about the ability for maybe even state governments to force people to get vaccinated or to have vaccine requirements. I mean, that's something that's already been ruled on, correct? I know Professor Koch, you mentioned, you made reference to that in a news interview a few months ago, right?
Oh, absolutely. I mean, it's interesting as a public health law professor and teaching. I've been teaching Jacobson versus Massachusetts for years, and it's fascinating that all of a sudden everyone knows about it. But I mean, it's a case from the very early 20th century, upholding a Massachusetts vaccination mandate. And that was, in fact, a mandate, not a test or vaccination choice. But that was fully upheld as within the public, the state's rights to protect the welfare and well-being of its citizens. And so my predictions at the time were that state mandates would generally be upheld based on that precedent. And generally, states are the jurisdictions that are empowered to prevent the spread of infectious disease. So generally, we have expected states to be the ones to pass these types of mandates. And for, I don't want to say for better or for worse, because I think it's unfortunate, most states have not, which again, as Professor Chandler mentioned, is why the Biden administration has taken this step in trying to enable, at least under the OSHA requirements, another 80 million Americans to be vaccinated.
Right. And if I could drop a footnote or a couple of footnotes to Professor Cook's points. The first is there's been an interesting effort in just the past year or so to recast the meaning of Jacobson and to say that it wasn't really a mandate that was at stake, but rather the choice was to get vaccinated or to pay a modest tax, something like actually the modern day Affordable Care Act before they got rid of the mandate. And that perhaps it didn't uphold a pure requirement to get vaccinated. And I have to say that that strikes me as a rather creative interpretation of Jacobson, but it's one that's been revived recently. The second thing I would add is you need to look at the facts of Jacobson. First of all, it upheld that vaccination requirement against a minister who, although he wasn't really pressing his religious concerns at the Supreme Court level, nonetheless, there were religious freedom issues that had been raised with respect to that, and the Supreme Court didn't seem particularly interested at that point. And the other thing I would tell you is, people talk about, well, there are side effects of the current vaccines, which is true. There are rare side effects of the current vaccine. The vaccine in question was a live vaccine related to smallpox, and there were quite a number of side effects of that vaccine. That was not a particularly safe vaccine, but the alternative was getting being subjected to smallpox, which I assure you was a very dangerous prospect. And so a little look at the history of the Jacobson case, I think, gives some insight into the scope of the ruling there.
Interesting. And I can attest that in the military, they still forced us to, or not forced, required us to get the smallpox vaccine. And it still has side effects. So that is interesting looking at the facts.
Right.
I think it's also interesting. So the Fifth Circuit does reference Jacobson, and kind of talks about that falling within the state's policing powers, and that, but maybe that those powers belong strictly to the states, and that therefore kind of speaking against the federal government's powers under the Commerce Clause, saying that that's not going to work, that the Commerce Clause doesn't allow the federal government to regulate non-economic inactivity, and so I'm curious. How does that argument work, and is there a counter argument to the Fifth Circuit's argument that the federal government doesn't have authority under the Commerce Clause to have vaccine requirements of this scope?
Right. So I think the counter argument is that the Biden requirement is not directed to the individual. It's directed to the employer. It's requiring the employer, and only large employers. That's why I think they drew the line at 100 employees, because at that point, if you got 100 employees, you're engaged in interstate commerce 999 times out of 1,000. And so you are regulating businesses. Now, it is true, just as any regulation of business will have an indirect effect on the individual, it's certainly true that these regulations will have an effect on individuals who are vaccine hesitant, as it's called. But I think it would be a stretch to say that because they affect the individual and potentially could cause them to get fired, that you're regulating non-economic activity. And so it would be quite an expansion of the non-economic activity doctrine to say that an effect on individuals' non-economic activity is a basis for saying that the law exceeds Congress's power under the Commerce Clause. If I could, there's one other point I want to sneak in here, which is a difference that now exists between state mandate requirements and federal mandate requirements. And you actually see this playing out currently in litigation over the vaccination mandate with the military, which is that some soldiers have said that the Religious Freedom Restoration Act gives greater deference to religious bases for objections to vaccination than is actually required by the Constitution. And although most states recognize religious exemptions for vaccination, there is probably no requirement under the Constitution that they do so if the public health need is strong enough. With respect to the federal government, there's greater grounds for stating, hey, my religion says that I shouldn't be vaccinated, and there must be other ways that you can assure public safety.
And to be clear, the OSHA regulations do have exemptions specifically for religious objections. So again, the drafters were very aware of sort of this preferred position of religion that currently exists and was addressing it appropriately, I think.
Before we continue, a special thanks to our sponsor, Vincent & Elkins, a global law firm with 11 offices and more than 700 lawyers committed to excellence in serving and advising its sophisticated clients in industries such as energy, finance, technology, real estate, media, and beyond. V&E lawyers are also proud to support pro bono clients across their communities. To help clients navigate complex areas of law, V&E hires the best and brightest law students and lawyers, valuing diverse perspectives and backgrounds. Visit www.velaw.com to learn more about V&E's Summer Associate Program and hiring opportunities. Start your success story at Vincent & Elkins. But we talked a little bit about this conflicting response to vaccination requirements between states and the federal government. Now we have court system divided. I mean, does the Supreme Court and the nation's response to these vaccine mandates, does it have greater implications than just the handling of COVID-19?
Absolutely. I think this case is going to have much longer trails than it just relating to COVID vaccination and masking. The state and the federal government's public health powers have been severely called into question over the last 18 months and challenged in so many ways. There has been a fair share of research looking at the curtailing of not just federal authority over public health emergencies, but also states, and what states can do to protect its citizens. And so we've seen laws passed not just in Texas, but I think in over 30-something states throughout the United States that will have enormous effects if and when the next pandemic hits. We'll be perhaps less prepared to address the next public health emergency because of that. And so I think that this case has a lot of implications for future cases. I think it's related to so many other things that are currently happening in this country when it comes to public health emergencies. I think a lot of the authority upon which we relied, like Jacobson, like the fact that the federal government had authorization or has congressional authorization since 1796 to impose quarantine. But I could see that being challenged going forward. There's many, we've seen CDC regulations being challenged in ways that we hadn't seen in the past. So I think that tides are changing in various ways, and this case is going to have enormous impact as well, I think, on so much of what we do from a public health perspective.
Right. I think we need to thread the needle here. And I think, although I fully believe in vaccinations, I believe in the vaccination mandate applied by states for COVID-19. I do think there's another side to the issue that we need to think about as courts resolve this, which is we have what many people would think of as a benevolent, correct scientific response by the federal government to a disease that's currently killed over 750,000 people, and probably by the time we get to another year, we'll be at 1 million. Okay? So we've got a very serious problem. And we have a vaccines which have proven themselves, at least so far as we can tell, to be darned safe. Okay? Before, though, we issue carte blanche for the federal government or states to start sticking things in our bodies, we ought to think about the situation where we have a federal government which is less perhaps benevolent or less scientifically oriented and wants us all to have ivermectin or whatever it is to combat COVID-26 or whatever the next pandemic is. And so I do think courts are right to focus on the authority of the federal government, on individual liberties. I regret to say that it looks like they are not threading the needle very well in this instance. And as a footnote, there is so far a perfect predictor of how a judge will decide this case. And that is, even though Chief Justice Roberts may think we don't have Obama judges and we don't have Trump judges, when it comes to this, we do. It's been a perfect predictor of who appointed you, has perfectly predicted how you come out on this opinion. But my bigger point is that there are legitimate interests here on both sides. And so while I think the Fifth Circuit, for example, overstated the matter, probably got it wrong, I do think courts ought to be careful before endorsing federal authority to inject substances into people's bodies.
And so I feel like what you just mentioned, Professor Chandler. It may influence your answer to my closing question. But feel free, if you all have something else you'd like to add before we close, feel free to say that. But I'm assuming, we've already assumed the mandate will likely be appealed from whatever the Sixth Circuit decides. And so I'm curious what you all think based on the Supreme Court's disposition, what's been litigated so far. I mean, how do you think the Supreme Court will decide if this comes up?
Well, I'll say I don't have great expectations that the OSHA regulations will be upheld at the Supreme Court level. I think based on even some of the questions from the Dobbs oral argument last week related to personal liberty and vaccine, and actually asking about vaccination requirements, I think that there's some indication from our current justices that this is not something that the court is willing to uphold. And also I think from a practical level, I don't know if it even unfortunately matters. The ETS is only intended to last 6 months. The OSHA had asked for expedited briefing to the Sixth Circuit. That was rejected, which is why we're not getting the briefs now until, 2 days from now. And so the fact is that it's unlikely that we're going to get any sort of ruling in the time frame that would actually allow implementation of this particular regulation to begin with. And so from a practical perspective, those who oppose the OSHA mandate are essentially already winning. There's a very small likelihood that we're going to see implementation of this mandate, which was intended to go into effect fully at the very beginning of January of 2022, anytime soon, or even perhaps within the window in which it was intended to be implemented.
Yeah, and I'll meet and raise Professor Koch. I will say that if the Sixth Circuit rules, as most people predict they will, which is to strike down the mandate, probably on some variant of the major questions doctrine, I wonder if there are 4 votes for certiorari in the Supreme Court to overturn that. If the Sixth Circuit were, and I think what would be a surprise to many people, to uphold the emergency regulations issued by OSHA, again, I wonder if the same Supreme Court that didn't like the eviction mandate because they wondered where on earth did administrative agencies get the power to make major changes in the real estate market, about which they might have been right, whether they're going to say that an OSHA, a grant of power to OSHA that had not been exercised in this fashion, and that does have major political ramifications, I think we have to acknowledge that, whether that's something that should be done by an emergency ruling when perhaps it could have been done by a quick notice and comment. So my suspicion is that if we're going to get greater vaccination mandates, it's going to be the result of political action, at least in some states, or the virus becoming so bad through Omicron or further mutations that the facts on the ground start to change.
Really fascinating stuff, and so happy to have both of you on. Really experienced and knowledgeable professors to talk about this, because I think there's a lot that's kind of unknown, moving around in the world, and so to give our listeners these really thoughtful insights, I think is extremely helpful as we kind of continue on to see how the Sixth Circuit and perhaps the Supreme Court will decide. So, Professor Chandler, Professor Koch, thank you so much for being on the show. It was truly a pleasure. And who knows, maybe I'll see you all next semester. Maybe I'll see you online. And thanks again.
Thank you.
Thank you for having us.
Thanks for listening. Emphasis Added is a podcast by the Houston Law Review. If you like what you heard, subscribe to us on YouTube or your favorite podcast app, and follow the Houston Law Review on social media, or check us out on houstonlawreview.org. Till next time.